I would like to give now then immediately the floor to Ms. Dory Reiling from the Netherlands. She is an IT and judicial reform expert and also retired senior judge from the Amsterdam District Court. Dory Reiling, I know you have been very active in this field, so please take the floor.
Simone, thank you. And thank you both my former speakers for your very interesting presentations. Congratulations to CCBE on its 60th anniversary. I'm really honored to be part of this very distinguished group of speakers. I have, as Simone said, worked on IT for justice for a long time, and I was given 10 minutes to talk about artificial intelligence and judicial decision making. So it's going to be very brief. But my presentation includes references for people who are interested to know more about AI and judicial decision making. So I will share my presentation with you. We tested this beforehand and then it worked. So if I now click share, you should be able to see it.
Yeah.
Okay. Yeah. Good. And you also see me, which is, I think, really an enhancement. So my talk is about artificial intelligence in judicial decision making. And you will recognize a lot of what has already been said. This talk represents a very brief overview of my thinking on the subject at the moment. It's one of my ongoing topics. I have written about it, and this is a 10-minute condensation of my thinking about AI for courts at the moment. So let's look at what I would like to talk about. My first subject will be AI in court practice. We tend to talk about AI in justice in very abstract terms, so I'm going to make that a little more concrete and practical. The second theme, of course, has to be so-called predictive, so-called justice, and you will find out what I mean by that later. The third subject is the ethical principles for the use of AI, as they were developed by the Council of Europe's Commission for the Efficiency of Justice. I helped them actually write those principles, the report on the principles. And finally, I would like to take a look at what those principles and the AI mean in terms of challenges for courts. And you see the reference to my article about this at the bottom of the page. So let's look at courts. Now, we tend to think that courts and judges are institutions that all the time make difficult judgments on difficult cases, but that is not actually what they do. If you look at the caseload, the civil caseload of the Dutch justice system, for instance, I have mapped them out for my PhD, which is also at the bottom of the page. And in fact, a lot of work done in the courts is title provision, without much thought to judgments or dispute points, because there aren't any. My group number 2, the bottom left-hand corner, is the notarial role of the courts. For instance, in handling most divorce cases or determination of labor contracts, where the judges rubber stamp legally valid agreements between parties. But my third group is settlement, which is cases which are a little more complicated, but somehow in the process of the court procedure get settled, and only group number 4 actually requires a full blown judgment. Now, there is a lot more to be said about that, but this also means that because courts have different processes, they have different technology needs. And that is why in my next slide, I show you what this means for the need and the use that courts could have from artificial intelligence. It's important to note that I always look at proven technology. I'm not interested in sales talk from technology that doesn't exist yet. So this page is about AI that is already proven technology. And if you see the top left-hand corner, structuring information is something that's already done. E-discovery in the US and in the UK are a good example of how that can work. For group number 2 and also for group number 3, a solution explorer for parties to figure out what would be a good way of proceeding for them. could be a solution, but I have not yet found practical examples of how that technology can work. So that's a maybe for both. I'm coming to the predictions later. And for the judgment group, where the really intellectual heavy lifting by the judges is done, AI might be able to help with research and analytics, but I also have yet to see serious proven technology in that field. So now let's look at so-called predictive, so-called justice. I call that so-called because I do not think that the AI makes predictions. It may be just a forecast, like, you know, a weather forecast. I live in a very rainy country, but sometimes the clouds just go somewhere else. So it's a forecast of something that might happen, but it might also not happen at all. And I would not call those predictions justice, because they are not part of they're not pronounced by a member of, let's say, the justice system. So, but look at what do we know about so-called predictive justice? There is a need for predictions, because unpredictable court case outcomes are a risk for the parties mainly, but also for society and for the economy in general, which is why there is a market for so-called predictive justice. And if we think predictive justice works, that is on the principle that past judgments, which is what the predictive justice uses, are correct. Now, I don't know about your justice system, but I know that in the repository of my justice system, there are judgments that are not correct, but that simply were not appealed for all sorts of reasons. You also need secure data, which in my experience is a problem almost everywhere. The data have to be correct, and the algorithm needs to be trained to be able to make the correct forecast. So these are all issues that make predictive justice or forecasting of court case outcomes a real problem. So I have one example of an algorithm that actually pretends it does predict outcomes. This is a very interesting case. The US tools that exist, and I don't have time to go into them pretty much, because they're all proprietary tools. So the workings are a trade secret. We don't know how they work. But with this one, the scholars who did this actually did describe pretty well what they did. So that makes this particular example interesting to look at. It claims to have an accuracy in the predictions of 79%, of 97%. Complexity reduction is done in both the process and in the decisions, which means that already a lot of complexity reduction is done before the outcome becomes apparent. I would like to ask, is 79% actually a good, an acceptable level of accuracy? If we don't know anything and we have to predict an outcome of something, yes, no means whether we say yes or no is 50% probably right. Now, we know from statistics by the European Court of Human Rights that once the court is involved, and that means that all those cases that are thrown out or that are dealt with by the office, cases that come to the court have an 84% probability of actually finding a violation of one of the human rights provisions. So is 79% good? I'm not so sure. What is interesting is that the scholars who did this exercise found out that judicial decision-making is significantly affected by the stimulus of the facts. Now, the judges in the audience may be really relieved to hear this. But I find this very interesting, because this is the kind of analytics that could help improve the quality of judicial decision-making. So that's why this is interesting. Let's move to the next page. Yes. For groups 2 and 3, what's the kind of AI that a solution explorer for parties could use. Some examples that I got from Canada are that they can be used for chatbot technology. They could be used for voice recognition and for completing forms, for instance, smart forms online to file cases or to find out what you need to do, translating content from one language to another, or forecasting possible outcomes. But this is all still in the future. My next chapter is about the ethical charter. As I told you, I was one of the people involved in putting the charter together. And there are, I won't talk about all of the principles there. I will talk about non-discrimination. I have something to say about transparency. And the final one, under human control, is, in my view, really the essential one. So let's start with the non-discrimination. It was already mentioned briefly that in the US, judges use tools to predict recidivism. And this tool is the one called Compass. That my colleagues in the US assure me there are better ones, but Compass is in use, and it's a proven fact that Compass discriminates between Black people and other people. Judges use it for a risk assessment, and it consistently rates Black people higher with regard to recidivism than white people. And there are many causes for this. We can learn a lot from this case. Are the judges biased? Well, actually, this tool was developed in order to eliminate bias by judges. Judges who are maybe slightly racist or have other biases. But in fact, it did not eliminate the bias in the judges at all. Are the laws biased? I leave that question to you. Are the programmers biased? Is there a lack of good data? Are the algorithms bad? These can all be causes for outcomes that are unfair. So look at transparency. Everybody says transparency is important, but what does it actually mean? So I'd like to take you on a very brief journey into current Netherlands case law on the topic. The Netherlands Supreme Court and the Council of State are in agreement that these are what do I call that? The criteria that transparency has to apply to use of artificial intelligence in justice. Disclosure needs to be full and timely and appropriate. And I'm wondering, they don't answer that question yet, whether that disclosure needs to be ex ante or ex post. The case law needs to assess the choices made and the data and assumption used in order to ensure effective legal protection. For instance, if you want to appeal a decision, you need to know how it came to be. And at the bottom, there are the ECHRs to the decisions. So that's transparency. And now the really hard part, because AI under user control is a real challenge for the courts. We all agree that the computer should not decide on its own. Well, in the case of Compass, it does not decide on its own, because that makes a forecast on the risk, on the recidivism risks, and then the judge actually decides. So in our criteria, that should be okay. In order for the judges to be able to know what they're doing, they have to be informed actors with regard to the use of the AI. They need to understand what the AI actually does. And the users need to be in control of their choices. They can decide what they should be doing with the AI's result. That is, what they do with the AI's result should be up to them. So, and this is actually my final slide. This is a very specific challenge for the courts, which I think at present courts still tend to underestimate, and that is judge profiles. Profiling judges. What would we profile judges for? Well, in order to reduce the uncertainty about case outcomes, clearly. But who is going to do it? Lawyers in the US already do it. The picture on the left is from a French site called Predictive, who used to offer it, but now they no longer do, and I will explain why in a little while. So by whom? Are the courts going to do it? Or are others are going to do it? And well, clearly judge profiling is going to be a market. But are the courts going to do it themselves in order to be prepared for the results of what the others are doing? And if they do it, for instance, will that be used for performance evaluation of judges? I had a very interesting conversation with one of my students who studies digitalization of the courts in China. And there they use AI to ensure consistency of decision making and of the procedures. Now, does that also evaluate judges who digress from the standard procedure? What does it do? I think this is a serious issue that courts need to really think about. So, finally, if the judge profiling, what are the answers going to be? Are they going to be ethical legal principles that have to be adhered to? Is there a need for regulation, for policy, or is this going to be banned? And this is what has happened actually in France, that using statistical information from the courts to profile judges has become a criminal offense with a really serious imprisonment threat. So these are really serious issues that courts have to think about. And I will leave you with some food for thought on this one.